15 November 2024, Washington, District of Columbia. The Death Penalty Information Center updates its national roster at 1400 hours. 7 names remain in a category the public assumes is far larger: women under active death sentences in the United States. The tally has not changed in 3 years. Statutes across 31 states authorize capital punishment for the most severe crimes, yet only 4 jurisdictions currently hold women on death row. Families who lost loved ones to violence wait for finality. The record shows something different: appeals stretching past 2 decades, moratoriums freezing cases indefinitely, protocol litigation stalling execution chambers, DNA motions reopening files long considered closed. Each case began with a jury's unanimous vote. Each now sits in a different legal posture: direct appeal, federal habeas, clemency review, or policy freeze. This is a story about 7 women, the courts that sentenced them, and the systems that determine whether justice means swift resolution or endless reconsideration. Federal habeas petition filing receipt marks the opening of Moss's appellate challenge in the federal system, 23 January 2025. Atlanta, Georgia. A clerk in the United States District Court for the Northern District of Georgia timestamps a federal habeas corpus petition at 9:47 in the morning. The case caption reads, "Moss vs. Warden." Tiffany Moss, sentenced to death in Gwinnett County in 2019, has exhausted her direct appeal before the Georgia Supreme Court. Her petition now enters the federal pipeline, where capital cases routinely spend years under review. The public expectation is clear: capital defendants receive rigorous representation at every stage, with experienced counsel combing trial records for constitutional errors. The Moss record reveals a striking departure. She waived her right to counsel during the penalty phase of her trial, presenting no mitigation evidence to the jury. Court-appointed standby counsel raised concerns about her competency to make that choice, but the trial court found her waiver knowing and voluntary. Moss was convicted of felony murder, and cruelty to children in the death of her 10-year-old stepdaughter, Imani Moss, in 2013. Prosecutors presented evidence that the child died from starvation and prolonged abuse. Gwinnett County jurors deliberated for less than 2 hours before returning a death verdict. The Georgia Supreme Court affirmed the conviction and sentence in 2023, noting the overwhelming evidence of guilt, but acknowledging the unusual procedural posture created by her self-representation during sentencing. Mitigation, evidence offered to reduce culpability or sentence severity, is a cornerstone of modern capital defense. Expert testimony about childhood trauma, mental illness, cognitive impairment, or abuse. Histories can shape jury perception and voting. Moss declined to present any such evidence. The appellate record now contains sparse material for federal habeas counsel to review. Georgia's capital appellate timeline moves faster than most states. From trial to state Supreme Court affirmance, Moss's case consumed 4 years, half the national median for death penalty appeals. Texas, Mississippi, and North Carolina cases routinely exceed a decade between sentencing and the completion of direct appeals. Federal habeas review, the next mandatory stage, adds another 8 to 12 years on average. Moss's petition raises claims of ineffective assistance of standby counsel and whether the trial court adequately explored her competency to waive representation. Both claims require detailed factual development, including expert evaluations that were never conducted at trial. The absence of a robust mitigation case complicates these arguments. Appellate courts weigh mitigation when assessing prejudice from attorney errors. When the defendant herself limited mitigation's presentation, courts face a paradox. Should they fault counsel for failing to present evidence the defendant refused to authorize? The Gwinnett County District Attorney's Office issued a brief statement after the Georgia Supreme Court ruling, acknowledging the victim's family and noting that the case would proceed through federal review as required by law. Imani's biological mother, Tiffany's co-defendant, received a life sentence without parole, often abbreviated LWOP, after pleading guilty. That outcome reflects prosecutorial discretion and plea negotiation, tools unavailable to defendants who proceed to trial and receive death sentences. The disparity between co-defendant sentences is a recurring theme in capital litigation. Courts examine whether similarly situated defendants receive proportionate punishment. Here, the legal question is not similarity of conduct, but the voluntariness of Moss's waiver and whether it forfeited her opportunity for a lesser sentence. Federal habeas review operates under strict deference standards established by the Anti-Terrorism and Effective Death Penalty Act of 1996, commonly called AEDPA. District courts may overturn state convictions or sentences only if state court decisions were contrary to clearly established federal law or involved an unreasonable application of such law. The standard is high. Nationwide, fewer than 10% of capital habeas petitions result in relief. Moss's case enters that narrow channel. The clerk's stamp marks the formal beginning. The legal reality is a process measured in years, not months. How should appellate courts weigh mitigation when the defendant limited its presentation at trial? Procedural order for DNA retesting. Updates the public docket and signals continued litigation decades after conviction. 3 February 2025, Dallas, Texas. A state district judge issues a procedural order authorizing additional DNA testing in State vs. Routier, a case that has been on the Texas Court of Criminal Appeals docket since 1997. Darlie Routier was sentenced to death for the stabbing murder of one of her 2 young sons in Rowlett, Texas, in June 1996. A second son also died in the attack. Routier has maintained her innocence, claiming an intruder committed the crimes. The trial focused heavily on physical evidence, including bloodstain patterns, a slash wound to Routier's neck that prosecutors argued was self-inflicted, and the absence of credible evidence supporting the intruder theory. The jury deliberated for less than 12 hours before returning a death verdict. The case became widely known due to media coverage of Routier's behavior in the days following the murders, including video of a graveside birthday celebration for one of the deceased children. Prosecutors argued the footage demonstrated a lack of genuine grief. Defense attorneys contended it showed a mother in shock, coping as best she could. The trial court admitted the video, and jurors later cited it as influential in their sentencing decision. Texas law requires a separate punishment phase in capital cases, during which the jury answers special issues about future dangerousness and mitigating circumstances. The jury found that Routier posed a continuing threat to society and that mitigating evidence did not warrant a life sentence. That verdict led directly to death. Texas offers LWOP as an alternative sentence in capital cases where the death penalty is not imposed. Routier did not receive that option under the law as it existed in 1997. Her direct appeal concluded in 2003 when the Texas Court of Criminal Appeals affirmed her conviction and sentence. State post-conviction proceedings followed, raising claims of ineffective trial counsel and newly discovered evidence. Those claims were denied. Federal habeas review consumed another decade, with the United States Court of Appeals for the Fifth Circuit ultimately rejecting her petition in 2015. The case appeared legally final. DNA technology has advanced significantly since 1996. Modern testing can analyze smaller samples, distinguish contributors in mixed profiles, and exclude individuals with greater certainty than methods available at the time of Routier's trial. Defense counsel filed a motion in 2021 requesting DNA testing of multiple items from the crime scene, including a bloody sock found in an alley near the house, fingerprints, and trace evidence on the murder weapon. Texas law permits post-conviction DNA testing if the results could establish actual innocence. The prosecution did not oppose limited testing, but argued that most of the requested items had already been analyzed and that new results would not alter the core evidence of guilt. The trial court granted testing on select items. Laboratory work began in 2023. Results have not yet been disclosed. The February order updates the testing protocol, extending the deadline for lab completion and requiring both parties to file status reports by June 2025. Public expectation often assumes that old cases conclude, that finality arrives after appellate exhaustion. The Routier docket tells a different story. Scientific advancements create new legal pathways. Motions filed decades after sentencing can reopen evidentiary questions. Families of victims who believed the case was settled learn that litigation persists. The older son's father has made public statements supporting continued scrutiny of the evidence, expressing hope that DNA results will confirm the conviction. Others in the extended family have voiced frustration with the delays. Texas executed more individuals than any other state between 2000 and 2024, yet Rudy A. remains on death row at the Mountain View unit in Gatesville. Her case is active, her sentence unchanged, but the docket remains open. Does advancing forensic science justify decades-long litigation or strain victims' quest for certainty? Department of Corrections Status Sheet Update reflects moratorium's effect on scheduling authority. 12 February 2025, Raleigh, North Carolina. The North Carolina Department of Public Safety updates its online offender database. The entry for Blanche Taylor Moore reads, "Active death sentence, no execution scheduled, moratorium in effect." Moore has been on death row since November 1990, when a Forsyth County jury convicted her of first-degree murder in the arsenic poisoning death of her boyfriend, Raymond Reed, in 1986. She was also suspected in multiple other poisonings, including her first husband and her mother-in-law, though she was tried only for Reed's death. Prosecutors presented evidence that Moore had access to arsenic-based ant poison and that Reed's exhumed body contained lethal levels of the substance. The defense argued that the evidence was circumstantial and that Reed's symptoms could have resulted from medical conditions. The jury rejected that theory. Psychiatric testimony presented during the penalty phase described Moore's difficult childhood and possible personality disorders, but jurors found aggravating circumstances outweighed mitigation. North Carolina imposed a de facto moratorium on executions in 2006, citing concerns about execution protocol and the need for comprehensive review of capital punishment procedures. No execution has occurred in the state since. Moore's direct appeal concluded in 1994 when the North Carolina Supreme Court affirmed her conviction and sentence. State and federal post-conviction proceedings followed the standard timeline, with her federal habeas petition denied in 2009. Under normal circumstances, the case would have been eligible for execution scheduling. The moratorium changed that reality. Clemency, executive action by a governor to commute a death sentence to life imprisonment, grant a reprieve, or issue a pardon, becomes the only remaining avenue for sentence modification once appeals are exhausted. North Carolina's clemency process requires a recommendation from the state's advisory board before the governor may act. Between 2000 and 2024, the board recommended clemency in 0 capital cases. Moore is housed at the North Carolina Correctional Institution for Women in Raleigh, the state's only facility for women under death sentences. Her housing classification is less restrictive than the Special Housing Units, SHUs, or Special Administrative Measures, SAMs, that apply in some federal cases and in states with maximum security death row facilities. North Carolina death row inmates have limited contact with the general population, but are not held in complete isolation. Moore has access to phone calls, mail, and periodic visitation, though regulations restrict movement and programming compared to general population inmates. She turned 92 in February 2025, making her one of the oldest individuals on death row nationwide. Age and health considerations often factor into clemency discussions, though North Carolina's board has not publicly indicated any review of her case. Raymond Reed's family members have occasionally spoken to media outlets, expressing frustration with the length of time between sentence and resolution. One relative stated in a 2015 interview that the moratorium felt like a denial of justice, leaving the family in perpetual limbo. Victims' rights advocates in North Carolina have argued that lengthy delays undermine the purpose of capital sentences, which jurors believe will result in execution. Opponents of the death penalty point to Moore's case as evidence that life sentences can achieve public safety without execution, noting that she's been incarcerated for 35 years with no prospect of release. The debate centers on whether the moratorium preserves fairness by preventing potentially flawed executions, or whether it negates the sentence juries imposed. The Department of Public Safety's status update is a single line in a database. It reflects a policy decision that has lasted nearly 2 decades. When law pauses executions statewide, what does active really mean for families awaiting closure? Fifth Circuit habeas denial order marks the conclusion of Carty's federal appellate remedies, 20 February 2025, New Orleans, Louisiana. The United States Court of Appeals for the Fifth Circuit denies Linda Carty's petition for rehearing en banc, the final procedural step before a potential Supreme Court petition. Carty, a British national, was sentenced to death in Harris County, Texas, in 2002 for the murder of 25-year-old Abigail Rodriguez during a kidnapping. Prosecutors alleged that Carty orchestrated the abduction of Rodriguez and her newborn son, intending to claim the child as her own. Rodriguez was bound, placed in the trunk of a car, and suffocated. The infant survived and was recovered unharmed. Carty has maintained her innocence, claiming she was framed by drug dealers she had previously worked with as a confidential informant for the Drug Enforcement Administration. The jury did not credit that defense. Trial evidence included witness testimony placing Carty at the scene and establishing her obsession with obtaining a baby. Carty's case attracted international attention because of her citizenship. The United Kingdom abolished the death penalty in 1969 and has since advocated globally for abolition. British government officials and human rights organizations, including Reprieve, have called for clemency review, arguing that Carty received ineffective assistance of counsel at trial. Her lead attorney had never tried a capital case before. He failed to present available mitigation evidence, including testimony about Carty's traumatic childhood in St. Kitts, where she experienced poverty and abuse, and expert psychiatric evaluation that could have addressed her mental state at the time of the offense. Federal habeas proceedings focused heavily on these claims. The district court conducted an evidentiary hearing in 2014, hearing testimony from multiple experts who reviewed Carty's background and trial record. The court found that trial counsel's performance fell below prevailing professional standards, but concluded that the deficiencies did not prejudice the outcome, meaning the jury would have imposed death even with better representation. The Fifth Circuit affirmed that ruling in 2022 and the February 2025 denial of rehearing forecloses further federal appellate review unless the Supreme Court grants certiorari, a rare event. Fewer than 1% of cert petitions in capital cases are granted. Carty's legal team now faces a choice: file a Supreme Court petition with minimal likelihood of success or pivot to clemency. Texas's clemency process requires a majority vote by the State Board of Pardons and Paroles, followed by the governor's approval. Between 2000 and 2024, Texas granted clemency in capital cases exactly once, a commutation based on mental illness and intellectual disability. The statistical reality shapes strategy. Carty's British nationality could be an asset in clemency advocacy, as international pressure has occasionally influenced Texas officials. It could also be irrelevant, as boards tend to focus on trial evidence and procedural fairness rather than diplomatic concerns. Abigail Rodriguez's mother has given several interviews over the years describing the ongoing pain of losing her daughter and the frustration of lengthy appeals. She stated in a 2019 news article that she wanted a finality, not endless delays. Texas executes more individuals than any other state, yet procedural litigation has extended many cases far beyond initial expectations. Carty's timeline, 23 years from sentencing to the exhaustion of federal habeas, is not unusual in modern capital practice. North Carolina's moratorium freezes cases after appeals conclude. Texas cases move through the system but face delays from protocol challenges, competency evaluations, and successive habeas motions. The contrast is procedural, not philosophical. Does international attention increase clemency scrutiny or leave the legal record unchanged? Expert mitigation report filed in state post-conviction proceedings documents trauma history presented belatedly in the appellate record, 5 March 2025. Austin, Texas, defense counsel in State v. Shepard files a supplemental brief in ongoing state post-conviction proceedings, attaching a forensic psychologist's report evaluating Erica Shepard's childhood trauma and cognitive development. Shepard was sentenced to death in Jefferson County, Texas, in 1995 for the murder of Marilyn Sage Mayer, a 43-year-old woman beaten and stabbed during a robbery in Houston in June 1993. Shepard was 19 years old at the time of the offense. 3 co-defendants received lesser sentences through plea agreements. Shepard proceeded to trial and received death. Texas law at the time permitted capital sentences for offenders aged 17 and older. The The Supreme Court later held in Roper v. Simmons, 2005, that executing individuals for crimes committed before age 18 violates the Eighth Amendment. Shepard was 19, placing her outside that constitutional protection. Subsequent cases, including Miller v. Alabama, 2012, have recognized that youth-related brain development and impulsivity affect culpability even for offenders over 18, though those rulings address juvenile life without parole sentences, not capital punishment. Shepard's trial attorney presented minimal mitigation evidence during the punishment phase. Jurors heard brief testimony about her difficult upbringing in Houston's Fifth Ward, a neighborhood with high poverty and crime rates. They did not hear detailed expert testimony about the severe physical and sexual abuse Shepard experienced from age 8, the cognitive impairments resulting from repeated head trauma, or the lack of effective parental guidance that left her vulnerable to negative peer influence. The forensic psychologist's report, completed in 2023, synthesizes school records, medical files, and interviews with family members to construct a comprehensive mitigation case that was never presented to the jury. Texas courts have repeatedly held that newly developed mitigation evidence does not warrant relief unless trial counsel's failure to investigate and present such evidence constituted ineffective assistance under Strickland v. Washington, 1984. The Strickland standard requires proof that counsel's performance was deficient and that the deficiency prejudiced the defendant, meaning there is a reasonable probability the outcome would have been different with competent representation. Shepard's appellate team argues both prongs. Trial counsel conducted minimal investigation into her background, relying instead on a cursory social history that failed to uncover documented abuse. The prejudice question is harder to establish. Texas juries answer special issues during capital sentencing, whether the defendant poses a future danger to society and whether mitigating circumstances warrant a life sentence. The evidence of Shepard's deliberate participation in a brutal robbery murder is strong. Prosecutors presented testimony that she actively participated in the beating and stabbing, not merely as a passive follower. The state's brief, filed in response to the supplemental mitigation report, argues that the jury's future dangerousness finding was supported by the facts of the offense and that additional background evidence would not have altered their assessment. The Texas Court of Criminal Appeals has not yet ruled on the motion. Marilyn Mayhere's family has maintained a public presence throughout the appeals process, attending hearings and providing victim impact statements. A son stated in a 2021 interview that he understood the need for legal review, but believed Shepard's youth at the time of the crime did not excuse the violence inflicted on his mother. Shepard's case timeline contrasts with Tiffany Moss's in Georgia. Moss's case moved from offense to federal habeas petition in 12 years. Shepard has been litigating for 32 years and remains in state post-conviction. Both cases raise competency and mitigation questions, but through different procedural lenses. Should youth-related mitigation carry more weight in older capital cases when societal and legal norms have shifted? Federal court order. Addressing lethal injection protocol challenge stalls execution scheduling. Pending resolution of Eighth Amendment claims, 18 March 2025. Jackson, Mississippi. A United States District Court judge issues a stay of execution in Chamberlain v. Commissioner, citing unresolved constitutional questions about Mississippi's 3-drug lethal injection protocol. Lisa Jo Chamberlain was sentenced to death in Harrison County in 2006 for the murders of her former boyfriend and his new girlfriend in Gulfport in 2004. Prosecutors presented evidence that Chamberlain shot both victims multiple times in a premeditated attack motivated by jealousy. The defense argued that she acted in a dissociative state triggered by years of domestic violence from the former boyfriend, but the jury found the aggravating circumstances, 2 victims lying in wait, outweighed mitigation. Chamberlain's direct appeal concluded in 2011, with the Mississippi Supreme Court affirming. Federal habeas litigation has consumed the subsequent 14 years, with the Fifth Circuit denying relief in 2023. The case appeared ready for execution scheduling. Mississippi, like many death penalty states, has faced recurring litigation over its execution protocol. The state uses a combination of midazolam, vecuronium bromide, and potassium chloride. Inmates and their counsel have argued that midazolam, a sedative, does not reliably render individuals unconscious before the administration of the second and third drugs, which cause paralysis and cardiac arrest. If the inmate remains conscious, the protocol may inflict severe pain in violation of the Eighth Amendment's prohibition on cruel and unusual punishment. The Supreme Court addressed similar claims in Glossip vs. Gross, 2015, holding that challengers must identify a feasible and available alternative method of execution to succeed. Mississippi inmates have pointed to single-drug pentobarbital protocols used in other states, but Mississippi officials have stated that pharmaceutical suppliers refuse to provide pentobarbital for executions, making that alternative unavailable. The legal stalemate continues. The March stay order does not resolve the constitutional question. It prevents Mississippi from setting an execution date while discovery proceeds on whether the state has made adequate efforts to obtain alternative drugs. Chamberlain's federal habeas petition raised multiple claims, including ineffective assistance of counsel for failing to present comprehensive mitigation evidence. Court records document her history of severe childhood sexual abuse, untreated post-traumatic stress disorder, and a pattern of abusive relationships in adulthood. Trial counsel presented some of this evidence but did not retain a forensic psychiatrist to testify about how trauma affected her mental state during the offense. The district court found the mitigation presentation adequate, though not exhaustive. The protocol litigation now supersedes those resolved claims. Victims' families often express frustration when protocol disputes delay cases that have completed all substantive appeals. The former boyfriend's mother submitted a written statement to the court in 2024, noting that 18 years had passed since her son's murder and the continued litigation felt like punishment for the survivors. Mississippi law does not provide for victim participation in protocol hearings, as those proceedings address systemic questions rather than individual case facts. The Harrison County District Attorney's Office has issued statements supporting the state's protocol and urging resolution of federal litigation. Chamberlain remains housed at the Central Mississippi Correctional Facility in Pearl, the state's designated death row for women. She has access to limited programming and outdoor recreation, though her movement is restricted compared to general population inmates. Mississippi's litigation delays echo North Carolina's moratorium, but arise from procedure rather than policy. North Carolina affirmatively halted executions through executive and legislative action. Mississippi officials have consistently stated their intent to carry out death sentences, but legal challenges and pharmaceutical access issues create de facto delays. The difference matters to families seeking closure and to defendants awaiting resolution. If no protocol is deemed lawful today, how can any capital timeline remain predictable? Racial Justice Act motion withdrawn. Illustrates the impact of repealed legislation on pending capital cases. 25 March 2025. Durham, North Carolina. A clerk files a notice of withdrawal in State v. Parker, closing a Racial Justice Act motion that had been pending since 2012. Carlette Parker was sentenced to death in 1999 for the murder of her husband, Marcus Parker, in Durham in October 1998. Prosecutors argued that Parker stabbed her husband during an argument and then staged the scene to appear as if an intruder had committed the crime. The defense presented evidence of years of severe domestic violence, including medical records documenting injuries and neighbors' testimony about shouting and threats. The jury found premeditation and rejected the self-defense claim. Parker's direct appeal concluded in 2004, with the North Carolina Supreme Court affirming. Federal habeas review followed, culminating in denial by the Fourth Circuit in 2015. North Carolina enacted the Racial Justice Act in 2009, allowing death row inmates to challenge their sentences using statistical evidence of racial bias in jury selection, charging decisions, or sentencing outcomes. Parker's attorneys filed a motion under the act in 2012, presenting data showing that Durham County prosecutors struck black potential jurors at higher rates than white jurors in capital cases. The state legislature repealed the act in 2013, but courts allowed pending motions to proceed. Parker's motion remained in limbo for years as appellate courts debated whether the repeal applied retroactively. In 2020, the North Carolina Supreme Court ruled that the repeal barred further consideration of RJA claims. Parker's counsel formally withdrew the motion in March 2025, acknowledging that no legal pathway remained under that statute. The withdrawal does not affect Parker's underlying death sentence, which remains active. North Carolina's moratorium, in effect since 2006, independently prevents execution scheduling. Parker's case illustrates how policy shifts, enactment and repeal of the RJA, imposition of the IDI moratorium, create legal uncertainty for defendants and victims alike. Marcus Parker's sister has spoken publicly about the case, stating in a 2018 interview that she believed Carlette manipulated the domestic violence narrative and that the evidence showed premeditation. She expressed frustration with the RJA litigation, viewing it as a delay tactic unrelated to the facts of her brother's murder. Defense attorneys have countered that systemic bias analysis is essential to ensuring constitutional sentencing, regardless of individual case facts. Parker is housed at the North Carolina Correctional Institution for Women in Raleigh, the same facility as Blanche Moore. Both women's cases completed federal habeas review years ago. Both face indefinite stays due to the moratorium. The procedural distinction is that Parker's appeals concluded more recently, 2015 versus 2009, but her sentence has been frozen longer in practical terms as Moore's case was already post-habeas when the moratorium began. That timing paradox raises questions about fairness. Two defendants with identical legal postures face the same outcome, no execution, but one has waited 26 years under sentence while the other has waited 35. Does the difference matter? North Carolina courts have not addressed that question as the moratorium applies uniformly regardless of case age. Mitigation evidence in Parker's trial included expert testimony from a psychologist who evaluated her history of domestic violence and diagnosed post-traumatic stress disorder. The prosecution did not dispute the abuse, but argued it did not justify premeditated murder. The jury's finding of aggravating circumstances, premeditation, and lying in wait foreclosed a life sentence under North Carolina law as it existed in 1999. Should two defendants with identical legal posture face different outcomes because states handle moratoriums differently? Updated federal habeas evidentiary hearing transcript reveals new expert testimony on competency evaluation standards. 10 April 2025, Atlanta, Georgia. A federal magistrate judge conducts an evidentiary hearing in Moss v. Warden, taking testimony from a forensic psychiatrist retained by Moss's habeas counsel. The psychiatrist reviewed trial transcripts, mental health records, and jail logs from the period leading up to Moss's decision to waive counsel during the penalty phase. His report, filed with the court in February, concludes that Moss exhibited signs of severe depression and possible dissociative symptoms that may have impaired her ability to make a knowing and voluntary waiver. The trial court had conducted a brief competency colloquy in 2019, asking Moss whether she understood the consequences of self-representation. She answered affirmatively. The judge found her competent to waive counsel. The psychiatrist's report argues that a more comprehensive evaluation, including standardized testing and review of her mental health history, would have revealed deficits in rational decision-making capacity. Georgia law requires that defendants be competent to stand trial and to waive constitutional rights, including the right to counsel. Competence to waive counsel requires not only an understanding of the formal consequences, but also a rational appreciation of how self-representation will affect the outcome. The Supreme Court has held that trial courts must conduct a searching inquiry before accepting such waivers in capital cases. Moss's appellate attorneys argue that the trial court's colloquy was insufficient given the stakes, life or death, and the absence of any mitigation presentation. The state's attorney, present at the April hearing, cross-examined the psychiatrist extensively, noting that Moss had no documented history of psychotic illness or intellectual disability, and that her answers during the colloquy were coherent and responsive. The state contends that dissatisfaction with the strategic choice to waive counsel does not render the waiver involuntary. The evidentiary hearing also addressed whether standby counsel, appointed by the trial court to assist Moss if she changed her mind, provided ineffective assistance by failing to intervene more forcefully. Standby counsel testified that he repeatedly advised Moss to allow him to present mitigation witnesses, including family members and a social worker who had evaluated her background. Moss declined. Standby counsel did not file a motion to reconsider the competency finding or to compel mitigation presentation over Moss's objection. Habeas counsel argues that standby counsel should have taken those steps. The state counters that doing so would have violated Moss's autonomy and right to control her defense. The magistrate judge took the matter under advisement with a recommendation to the district court expected by August 2025. Manny Moss's biological father, who was not involved in the criminal case, has occasionally spoken to media about his daughter's death. He stated in a 2020 interview that he wanted accountability for those responsible, but expressed ambivalence about the death penalty, noting his religious opposition to state executions. His perspective contrasts with many victim family members who view capital sentences as necessary justice. The diversity of victim perspectives rarely appears in court records, which focus on legal procedure rather than the emotional complexity of loss and punishment. Moss's case now presents procedural issues similar to those in Darlie Roudier's DNA litigation. Both involve post-trial developments that could reshape the record but face high legal bars to relief. Chamberlain's protocol litigation represents a third kind of delay, unrelated to individual case facts. When science or competency debates evolve, how much reconsideration is enough and who decides? Fifth, Circuit published opinion on procedural default shapes the boundaries of habeas review for similarly situated capital defendants, 20 April 2025, New Orleans, Louisiana. The Fifth Circuit issues a published opinion in Chamberlain v. Commissioner, affirming the district court's denial of an evidentiary hearing on Chamberlain's ineffective assistance of counsel claim. The opinion, 23 pages, explains that Chamberlain's trial attorneys did not raise certain mitigation arguments during state post-conviction proceedings, thereby procedurally defaulting those claims. Federal courts may excuse procedural default only if the petitioner demonstrates cause for the failure and resulting prejudice or shows actual innocence. The circuit panel found neither. Chamberlain's habeas counsel argued that trial counsel's failure to investigate and present comprehensive trauma-related mitigation constituted cause, as ineffective state post-conviction counsel failed to recognize the issue. The Fifth Circuit rejected that theory, citing Martinez v. Ryan, 2012, which allows ineffective post-conviction counsel to serve as cause only in states that require initial ineffectiveness, claims to be raised in post-conviction proceedings rather than on direct appeal. Mississippi permits such claims on direct appeal, removing the Martinez exception. The ruling does not address the merits of Chamberlain's mitigation evidence. It holds only that federal courts lack authority to consider the claim because of procedural default. The practical effect is significant. The comprehensive forensic reports documenting Chamberlain's childhood sexual abuse, PTSD, and impaired decision-making during the offense remain outside the reviewable record. The circuit opinion emphasizes deference to state procedural rules, a cornerstone of AEDPA. Habeas counsel filed a petition for rehearing en banc on April 25, arguing that the panel's interpretation of Martinez conflicts with recent Supreme Court precedent. The Fifth Circuit rarely grants rehearing in capital cases. Between 2010 and 2024, the court granted en banc review in fewer than 5% of such petitions. Victims' families received notice of the ruling through the Harrison County District Attorney's Office, which issued a press release describing the decision as a significant procedural victory. The former boyfriend's mother, quoted in the release, stated that she hoped the ruling would bring the case closer to resolution. The statement did not address the ongoing protocol litigation, which remains a separate barrier to execution scheduling. Mississippi has not set an execution date for any inmate since 2012, when the state carried out its last execution using a prior protocol. Pharmaceutical manufacturers' refusal to supply execution drugs has forced Mississippi and other states to revise protocols repeatedly, triggering new rounds of litigation, each time. The April opinion resolves one layer of Chamberlain's case, while another remains open. The opinion's publication means it serves as binding precedent in the Fifth Circuit, affecting future capital habeas cases from Texas, Louisiana, and Mississippi. Defense attorneys in those states must now ensure that all ineffective assistance claims are raised in state post-conviction proceedings, even if the state permits such claims on direct appeal or risk federal default. The ruling tightens an already narrow pathway to relief. Chamberlain's case is not unique. Multiple death row inmates in the circuit face similar procedural bars where the substance of their claims, whether mitigation was adequate, whether counsel investigated properly, never receives federal review because of timing or pleading errors in state court. The deference framework prioritizes finality and respect for state court judgments. Critics argue it sacrifices accuracy. When deference governs review, how often can new evidence genuinely shift an outcome? Governor's executive order, reaffirming moratorium, provides public explanation of continued policy freeze 2 May 2025, Raleigh, North Carolina. Governor's office staff distribute an executive order reaffirming the state's moratorium on executions, citing ongoing concerns about protocol reliability and racial disparities in capital sentencing. The order, signed at 1000 hours, states that no execution warrants will be issued until the General Assembly enacts comprehensive reforms addressing those concerns. The statement marks the 19th consecutive year of North Carolina's de facto execution halt. Blanche Moore and Carlette Parker remain on death row under active sentences that cannot proceed to execution. The order references a legislative study commission established in 2023 to review capital punishment practices. The commission's report, released in January 2025, recommended maintaining the moratorium pending further study of jury selection data and clemency process improvements. The General Assembly has not acted on those recommendations. Moore's case, now 35 years post-sentencing, represents the longest unexecuted capital sentence among women currently on death row nationwide. Raymond Reed's extended family submitted a letter to the governor's office in March requesting clarity on whether the state intends to ever carry out the sentence or whether it should be formally commuted to life imprisonment. The letter, obtained through a public records request, describes the emotional toll of perpetual uncertainty and asks for a definitive resolution. The governor's order does not address individual cases, applying instead as a blanket policy. North Carolina's clemency process requires the advisory board to review petitions and make recommendations, but the board has not met to consider capital cases since 2015. The procedural freeze extends beyond executions to clemency review itself. Parker's case illustrates similar frustration from Marcus Parker's family. His sister has testified before legislative committees, arguing that the moratorium undermines jury verdicts and denies victims' families the closure promised by the justice system. She has also noted that Carlette Parker has been incarcerated for 27 years without facing execution, raising the question of whether the death sentence retains any practical meaning. Supporters of the moratorium counter that preventing potentially wrongful or racially biased executions justifies the delay, and that life sentences without parole achieve the same public safety goal. The debate centers on competing values, finality for victims versus safeguards against irreversible error. The executive order's reference to racial disparities draws from extensive research showing that black defendants in North Carolina have been sentenced to death at disproportionate rates, and the cases involving white victims are more likely to result in capital charges. The repealed Racial Justice Act sought to address those disparities by allowing statistical evidence in sentencing challenges. Its repeal left no procedural mechanism for systemic bias claims. Parker's withdrawn RJA motion is a direct consequence of that legislative reversal. The governor's order suggests that future reforms could revive such mechanisms, but no specific proposal has advanced. Meanwhile, the moratorium continues, affecting Moore and Parker equally, despite their different procedural histories and different offense circumstances. North Carolina law allows governors to commute sentences unilaterally in extraordinary cases, though modern governors have rarely exercised that power in capital matters. The May order does not signal any intent to commute Moore's or Parker's sentences. It maintains the status quo: active sentences, no executions, no clear timeline for resolution. Do long pauses preserve fairness or erode the meaning of a capital sentence? Texas Board of Pardons and Paroles, Clemency Docket. Lists pending petitions and historical grant rates, 15 May 2025. Austin, Texas. The Texas Board of Pardons and Paroles publishes its quarterly docket of pending clemency petitions. Linda Carty's name appears on page 4, with a notation indicating that her petition was filed on April 30th and that a preliminary review is scheduled for July. The docket also includes summary statistics. Between 2000 and 2024, the board received 137 clemency petitions in capital cases and recommended commutation in 1. That single grant occurred in 2021 when the board recommended clemency for a defendant with intellectual disability and severe mental illness. The governor approved the recommendation. The statistical reality shapes expectations. Carty's petition argues ineffective assistance of trial counsel, her British nationality, and the disproportionate severity of her sentence compared to co-defendants who received life terms. None of those factors precisely match the 2021 case. Texas clemency procedures require the board to vote on whether to recommend commutation. A majority vote is necessary. If the board recommends clemency, the petition advances to the governor, who has sole authority to grant or deny. If the board does not recommend, the governor cannot act unilaterally except to grant a one-time 30-day reprieve. The process prioritizes finality and deference to jury verdicts. Board members review trial transcripts, victim impact statements, and any new evidence presented by defense counsel. They do not conduct evidentiary hearings or re-examine witness credibility. The review is a paper process, completed within weeks. Carty's counsel submitted a 200-page petition, including affidavits from British consular officials, trial counsel's admission that he was unprepared for capital litigation, and expert evaluations documenting Carty's trauma history. The board has not indicated whether it will schedule oral argument. Abigail Rodriguez's mother submitted a victim impact statement to the board in early May, describing the loss of her daughter and grandson's mother and requesting that the board deny clemency. She wrote, "Nothing will bring Abigail back, but the jury's decision should be respected." The statement is part of the record the board will review. Texas law guarantees victims' families the opportunity to provide input during clemency proceedings, though board votes are not bound by those statements. The balance between victim voices and defendant mitigation is a recurring tension in clemency review. Boards must weigh the harm caused. Here, a young woman's murder and a newborn's traumatic separation from his mother, against evidence that may reduce the defendant's culpability or suggest the sentence was disproportionate. Carty's nationality is a complicating factor. The United Kingdom has formally requested clemency, and international human rights organizations have submitted amicus briefs. Texas officials have historically been skeptical of foreign intervention in domestic legal matters, viewing it as inconsistent with state sovereignty and jury authority. The docket's publication draws no media attention. Clemency petitions are routine filings, and most are denied without public comment. Carty's case may attract coverage if the board schedules argument or if the governor issues a statement. For now, the petition sits in the queue, one of 11 capital clemency matters pending statewide. Erica Shepard's name does not appear on the docket. Her appellate team has stated publicly that they will pursue clemency only after exhausting state and federal habeas remedies, a process still ongoing. The strategic choice reflects the belief that premature clemency petitions may be dismissed as duplicative of pending litigation. If clemency is seldom granted, does it still function as a meaningful remedy? Resentencing Trend Report from Death Penalty Information Center provides comparative data on capital sentence outcomes nationwide. 25 May 2025, Washington, District of Columbia. The Death Penalty Information Center releases its annual report on capital sentencing trends, noting that 3 states, California, Oregon, and Pennsylvania, have converted multiple death sentences to life imprisonment through governor-initiated commutations or court-ordered resentencing over the past 2 years. The report documents that 20 women were removed from death row nationwide between 2000 and 2024 through reversals, commutations, or natural death. 7 remain. The report includes a section on Mississippi where protocol litigation continues to delay executions indefinitely. Lisa Chamberlain's case is cited as an example of procedural exhaustion. Federal habeas denied, protocol challenge unresolved. The policy consequence is a de facto life sentence, though the legal status remains death. Mississippi prosecutors have acknowledged in court filings that obtaining a constitutional execution protocol may take years if it is achievable at all. The report notes that North Carolina's moratorium, now entering its 20th year, has effectively converted all death sentences in the state to life terms without formal resentencing. Moore and Parker remain under sentence of death, but the practical outcome is indistinguishable from LWOP. Families of victims in North Carolina capital cases have increasingly called for legislative action to either resume executions or commute existing sentences, ending the legal and emotional limbo. The General Assembly has not acted. The report's comparative analysis shows that states with active execution chambers, Texas, Georgia, Alabama, complete capital cases faster but face higher rates of post-execution exoneration claims, as shorter appellate timelines reduce opportunities for new evidence review. States with moratoriums or protocol challenges avoid execution but create prolonged uncertainty. Raymond Reed's family held a private memorial service on the 39th anniversary of his death in October 2024. A relative told a local reporter that the family had made peace with the fact that Moore will likely die of natural causes before the state acts. The statement reflects a broader trend: aging death row populations outliving their sentences. Moore, at 92, is statistically unlikely to survive long enough for the moratorium to lift and an execution to be scheduled. The policy freeze becomes a de facto commutation. The DPIC report raises the question of whether formal resentencing would provide greater clarity and respect for victims' families, acknowledging that the promised outcome will not occur while preserving the record of the jury's judgment. No North Carolina official has proposed such legislation. Marcus Parker's sister continues to attend legislative hearings advocating for moratorium repeal or sentence commutation. She has stated that either outcome would be preferable to the current stasis. Her perspective represents one segment of victim family opinion. Others, including families in Texas cases, have expressed strong support for carrying out death sentences as imposed. The diversity of victim perspectives complicates policy debates, as no single position represents all families affected by homicide. The DPIC report includes excerpts from victim impact statements filed in clemency proceedings, illustrating the range of views. Some families seek execution as necessary justice, others request clemency on religious or moral grounds, and still others express ambivalence or exhaustion. The commonality is a desire for resolution. The report's final section addresses trends in jury sentencing. Death sentences nationwide have declined by 70% since 2000, driven by broader availability of LWOP as an alternative and juror reluctance to impose death in cases with strong mitigation evidence. The 7 women currently on death row were sentenced between 1990 and 2019, spanning an era of changing capital punishment practice. Their cases remain active as artifacts of prior legal norms, while current practice moves toward life sentences in cases that would have once resulted in death. 10 June 2025, Atlanta, Georgia. The United States District Court for the Northern District of Georgia issues a scheduling order in Moss v. Warden, setting a status conference for September 15th to review the magistrate judge's recommendation on the evidentiary hearing record. The order notes that both parties will have the opportunity to file objections to the recommendation before the district judge issues a final ruling. Tiffany Moss remains on death row at the Arundel State Prison in Alto, Georgia. Darlie Routier remains at the Mountain View Unit in Gatesville, Texas, awaiting DNA test results. Linda Carty awaits a clemency board vote in Houston. Erica Shepard continues state post-conviction litigation. Lisa Chamberlain's protocol challenge remains unresolved in Mississippi. Blanche Moore and Carlette Parker remain frozen under North Carolina's moratorium. 7 women, 4 states, 7 distinct procedural postures. The calendar entry is a single line in a public database. It represents years of litigation yet to come. Federal habeas cases in capital matters average 8 years from petition to final ruling. Moss's case, filed in January, will likely extend past 2033 before all federal remedies are exhausted. Routier's DNA results, expected by late 2025, could reopen evidentiary proceedings or confirm the existing record. Either outcome triggers further motions, hearings, and appeals. Carty's clemency petition will receive a board vote by July, But even a denial does not foreclose future petitions if new evidence emerges. Shepard's mitigation litigation depends on the Texas court's willingness to find trial counsel ineffective and prejudice from that ineffectiveness, a two-part standard rarely satisfied. Chamberlain's case hinges on whether Mississippi can demonstrate a constitutional execution protocol, a question tied to pharmaceutical availability and evolving Eighth Amendment standards. Moore and Parker await policy change, legislative action to lift the moratorium, or gubernatorial commutation to end the legal fiction of an active death sentence that will never be carried out. The contrasts among these cases illustrate how geography determines outcome. Identical conduct in different states yields different sentences. Similar procedural posture in different states yields different timelines. A defendant in Georgia may face execution within 15 years of sentencing, while a defendant in North Carolina faces indefinite incarceration under a death sentence that exists only on paper. Texas cases move through appellate review, but stall at clemency or protocol litigation. Mississippi cases exhaust appeals but cannot proceed to execution. The Eighth Amendment requires proportionality in sentencing. Similar cases should receive similar punishment. State lines create disparities that challenge that principle. Does proportionality depend more on the crime or the jurisdiction where it occurred? Victim families navigate these disparities without control over outcomes. Some receive finality through execution. Others receive finality through natural death of the defendant. Still others wait in uncertainty, their cases trapped in procedural or policy freezes. The justice system promises resolution. The record shows fragmentation, appeals that stretch decades, protocols that fail constitutional scrutiny, moratoriums that last longer than many life sentences, clemency processes that grant relief in fewer than 1% of cases. The 7 women on death row embody that fragmentation. They are not symbols or statistics. They are named individuals convicted of specific crimes, sentenced under specific laws, reviewed under specific procedures. The victims they harmed are also named individuals: Raymond Reed, Abigail Rodriguez, Marilyn Meager, Marcus Parker, Imani Moss, and others whose families await answers. The calendar entry schedules a conference. The conference will schedule briefing. The briefing will lead to a ruling. The ruling will trigger appeals. The appeals will consume years. The process continues because the law requires it, because appellate rights are constitutional, because finality must coexist with accuracy. The docket remains open. The next scheduled status check, September 15, 2025.